Hi, and thank you for joining us for the latest episode of Decoding Appeals. My name is Owen Wolfe. I'm a partner at Seyfarth Shaw's litigation group and also a co-lead of Seyfarth's appellate group. And I'm joined here today by seasoned appellate litigator Eddy Salcedo. Eddy, how are you?
Good, Owen. How are you?
I'm hanging in there. Excited to talk about appellate briefs today and, getting your thoughts about strategies and ideas for having the best appellate brief you possibly can. And I think just to sort of take a step back, it's important to think about how you actually get to that point in your appeal brief where you can actually make arguments and make sure that you've preserved everything for the appeal so that you can even raise it in your brief. And I think in that sense, a lot of folks think, oh, I'm not going to bring in an appellate litigator until after the trial or after this particular trial court ruling. But that can be a little bit risky because you want to make sure that if there's an adverse ruling during the trial court proceedings, it doesn't go unchallenged, I should say, and you make sure that you preserve the opportunity to appeal from that ruling.
That's a really good point, Owen. What a lot of parties sometimes don't understand or tend to forget is that having your appellate counsel plugged in at an early stage has benefits not only to ensure that you have preservation of the right arguments throughout the case, but in certain jurisdictions, of New York being one of them, in New York State Court, you can do what's called an interlocutory appeal. Normally in federal court, you have to wait until there's a dispositive, the case is completely over, either at a summary judgment stage or at a trial stage, before you can then bring your appeal up to the circuit court. And at that point, everything will get brought up all at once. But New York State Court, practically every single decision that a lower court makes can be appealed from. Discovery motions, a motion to dismiss or a partial motion to dismiss, motions for injunctions, injunctive relief. They can all be appealed from. And if you have your appellate counsel plugged in early on, you don't have to wait until the case is over in order to bring that appeal. So something like a discovery motion where you're trying to either obtain a piece of discovery or exclude a piece of discovery, if you lose that motion in federal court, you pretty much have to play the case out and then at the end make the argument to your circuit court that was reversible and you have to start all over. Whereas in court with interlocutory appeals like New York State Court, you could appeal that immediately and potentially either get that piece of evidence or have it excluded before you even get to a summary judgment phase. Similarly, with injunctive relief, you can move up and try to get that. So, having that appellate counsel plugged in early who can flag something as simple as, hey, guys, we can still take an appeal from this now because we're in an interlocutory state versus having to wait until the end. The other advantage, even if you're in a state that doesn't have that ability, if you're just in regular federal court, having appellate counsel plugged in is going to make sure that all of the arguments that you need preserved are preserved, both prior to trial and then during trial. A lot of times it's as simple as making an objection, even if you know the objection is going to be denied. You still want to make that objection so that you have it preserved. Or if a certain document you're trying to get in, you at least attempt to get it in, even if you know it's not going to get in. Or you make sure you interpose certain arguments during motions to ensure that they were before the court and before the court properly. Litigation has a lot of thorns to it. It has a lot of moving parts. So just having that extra pair of eyes on it can be incredibly helpful. The way I like to describe it is that your appellate counsel could keep a 10,000-foot view of the case to ensure that the particular issues that you're trying to preserve remain in the picture. Because if they're not in that picture, you're not going to be able to appeal it down the road. So it's just a matter of having that input to make sure that you have everything preserved and that you can move forward. And once you have everything preserved, then you can go about best putting it before the court and putting your best argument forward on a brief.
Yeah, yeah, absolutely. And that's so important. I mean, you and I have been involved in appeals in New York State Court where our opponent tried to raise a brand new legal theory for the first time on appeal. They never argued it below. And the appellate court said, sorry, we're not going to consider that because you never raised it below. So, yeah, I think, like you said, having that appellate lawyer plugged in from the get-go and saying, hey, make sure you get all your arguments out on the table is key. And then, as you said, once you've done that and the arguments are hopefully all preserved, then you get to the point where you're actually putting those arguments into the brief. And, I think we all know that all courts across the country are overwhelmed. They have a lot of backlogs, and particularly for appellate courts, because the issues that they deal with tend to be more complicated. They're dealing with a lot. It's important to try to grab their attention from the get-go. And I think there are a lot of different ways that you can do that in the brief right up front in your preliminary statement. It could be a key quote from testimony or a document, or I've even seen folks do quotes from famous movies or things like that, something to really encapsulate what's going on and get the court interested up front. Or if not a quote, maybe just a sort of a line that summarizes the key takeaway and why the court should be paying attention here.
I totally agree. I mean, it's something as simple as getting the court's attention early can be so beneficial. I mean, you've got a panel, it's either, a three judge or a five judge panel, or sometimes you just have the single judge. And, like you said, there's a backlog, there's a ton of cases, and you just want something to catch their attention, to pay attention, not only to that one statement you're making, but for everything that comes after that. So when it comes to the appellate brief and even appellate argument, you really want to present stuff in the most strategic, logical fashion to draw the court to the conclusion that you're trying to get them to. It's not just a matter, some attorneys, will use their table of contents to tell the story. They see the highlights, point one, court below is right, point two, because they did this and they did that. So then just looking at the table of contents kind of tells your story. But even above and beyond that, you want to lay it out in a manner that makes the court think, okay, this is the important part. I should pay attention to this part, and here's what supports that part. Anecdotally, I had a situation where we won a pretty decisive victory at the trial court level on a motion for summary judgment. Our client was able to obtain significant rights to a roof, pertinent to an apartment, a very small apartment. In fact, the terrace that the court ended up granting our client was over two times the size of the apartment itself. It was based on a contract interpretation. It was based on a course of conduct between the parties, and on appeal, opposing counsel decided to do the throw everything on the wall technique. They made scattered arguments based on the documents, based on the arguments, based on select portions of testimony, based on select drawings, but basically threw everything at the appellate court completely. So their key argument, what at least I would have thought was their key argument, was that this disparity between the size of the apartment and the size of the terrace got a page and a half of their brief. In opposition, our respondent's brief focused in on exactly why the court was right, the exact portions of the contract of sale that led to believe that from the beginning of the relationship, this was the party's intention, the course of conduct over 30 years, the how the building was set up and how the spaces were used. We basically highlighted every single fact that the court below relied on. We highlighted the specific sections that the court relied on, and then we highlighted the case law that the court below applied, and then basically told the appellate court all of this put together means no error, fact or law or analysis, affirm. And then on reply, the guy goes again, just goes all over the place. At oral argument, he stands up, doesn't get two words in, and he starts getting peppered with questions about everything, like every little thing. There was no cohesive argument he could even attempt to make during his argument section because they were attacking different sections of it. When it came my turn to stand up, the questions to me were focused literally on the law and the contract itself. And then on reply, once again, it was scattershot. I mean, we were able to get it affirmed, but it was a perfect example of if you don't focus the court and if you try to do everything at once, it's odds are you're going to fail. Throwing everything on the wall is just not going to work. So again, having your appellate counsel in from an early time will allow you to focus what the important issues are and you may lose a decision or you may lose a ruling. And you may mention it in a footnote, but if it's not the big argument, your appellate counsel can tell you, okay, guys, we put a pin in that. Let's focus in and make sure that we have the record fully developed on this point or this issue, such that when it comes time to bring the appeal, we can really flesh out how she was right ruling in our favor or how she was wrong ruling against us, because we have preserved and have good facts and good law supporting that argument.
Yeah, absolutely. Yeah, I think that self-editing is so key. You just can't throw every single possible argument into an appellate brief, not only for word limit or page limit reasons, but also just as you said, if you don't focus the court, they're going to miss the key elements. And I'll go ahead and throw a war story in there as well. Had a situation where I was involved with a trial. And, as our viewers may know, when you are at trial and your witness is being cross-examined, you can't speak with that witness until the cross-examination is over. So, for example, my client, they were the defendants. So when the defendants were testifying or were being cross-examined by the plaintiff's lawyers, we couldn't speak with the defendants until the cross-examination was over. And the judge in that case bent over backwards to make sure that the plaintiffs were never in a situation where their cross-examination went on so long that they wouldn't be able to speak with their lawyers overnight. So, for example, if the trial was supposed to end at 5 o'clock for the day, the judge would say, "Oh, the plaintiffs are still testifying. Let's end at 5:30 today to make sure that we can finish the cross-examination." And yet, when it was the defendant's turn, the court stopped immediately at 5 and was like, "Okay, that's it. We're coming back the next day. Defendant's counsel, you can't speak to your witness." And even worse, on top of that, this was on a Friday, so we couldn't speak to the witness all weekend. And, eventually we go up on appeal. And, certainly that was a moment that was very frustrating and, frankly, seemed to suggest some sort of maybe bias is too strong of a word, but, the judge sort of treating the parties a little bit differently there. But it's not something that the appellate court would really care about or that we could really make an argument out of on appeal. So, as frustrating and maddening as it is, sometimes you just have to let that kind of stuff go and really focus in on the key appellate arguments.
I like to refer to most appeals as surgery. You want to get in there, you want to be precise, you want to get right to the exact issue that needs to be treated, needs to be dealt with, and then get out. So, as with, you know, any surgery, you want to have your surgeon involved as early as possible to be able to provide input and be able to assist to make sure that the procedure is as successful as possible. So it's just another asset. It's another tool to have. And in my experience, cases where I'm involved in that I get plugged in early, when it comes time for the appeal, it's generally easier to go about getting that done.
Yeah, yeah, absolutely, absolutely. Well, before we part, any other parting words of wisdom or things that folks should keep in mind when they're working on an appellate brief?
Less is more. Flowery doesn't carry the day as much as you think it will. Pithy does. But most importantly of all is focus. Focus yourself, focus your arguments, and focus the court. And if your respondent and the other side fails to focus the court, take advantage of that mistake, and then you, in response, focus the court as to why the court, the lower court was right. So as long as you're always driving towards that, keeping everything focused and keeping the issues discrete, you're going to increase your likelihood of success.
Yeah, absolutely. I couldn't agree more. And I frequently see appellate briefs where the sort of factual background section is just going on and on and on. And it's hard to keep your attention span just as even a very diligent human being. And yeah, making sure that it's laser focused and absolutely, as you said, less is more. I think that's an important thing to keep in mind. Well, it's been great chatting with you about appellate briefs. Really appreciate it.
Thank you, Owen. It's been a pleasure speaking with you as always.
And thank you to our viewers. We'll see you next time.